It's really a nice segue from last panel to this panel. Sherry already asked a question about data supplementation, which is a life science issue, and David Cohen also mentioned. Of course, there are patent licensing, IP licensing, but you got more important things to worry in life, your family, your life. And this is what is it about. One of the themes of our panel going to be, how do you deal with revenue generation, the human needs? And with all due respect to the mobile industry, cell phones are important, but without one, you still live. Without a drug, you die. And that's the perhaps indicates the unique challenges of the life science industry and the issue again dealing with balancing human need, the revenue generation versus human needs. And the other theme of our panel, if you bear with me, is the high risk of the life science research. And actually, by accident, I saw this quote just a couple of days ago. I think really summarized the risk very nicely. Ever tried, ever failed, no matter. Try again, fail better. And I'll leave the details to my three distinguished speakers here to explain the high risk and the issue, the challenge of dealing human revenue generation versus human needs, and the high risk, of course, included in there is important of the patenting. So with that, it's my pleasure to introduce to you on my left-hand side here, Lian Sun-Hoffman, who is the former Asia chief advisor for biotechnology industry organization. On my right-hand side, Knowles, who used to be the chief patent counsel for GlaxoSmithKline. And Sherry now runs I think it's a consulting firm, Knowles IP Strategies. And far right, Issi Rozen from Broad Institute. If you're not familiar with, probably very few people are not familiar with the CRISPR technology, but I'll leave the details to Issi. Issi is the Chief Business Officer of Broad Institute. And by the way, if it looks like a jazz musician to you, it's because he is one. He's, in addition to the businesses, he's also an accomplished jazz musician. If you hang on to the end after the... I found out from the dark world of internet. If you stick to the end, there will be surprise performance on the stage. With that, perhaps let's start with Sherry to, along those two themes, explain some of the things that he did before and doing right now, and we'll then connect with Broad Institute and Lian.
Okay, well, thank you, and good afternoon. We want to thank the Patent Office for hosting this very interesting conference on licensing. And I liked your quote because at the end of the quote it says, "Feel better," which means the drug got approved, and you're all feeling better. So we're going to talk a little bit about life sciences, biotechnology, what's the state right now in the licensing, both in the United States and internationally. In the group here, just raise your hand if you're involved in pharma or biotech. Is anybody? Okay, so we've got a couple of people here in that. That's great. So we've been talking a lot today about IT licensing, about copyright licensing, motion pictures, cell phones, etc. Completely different licensing model than what you have in pharmaceutical and biotech. I mean, you can't even lay one on top of the other. One of the main purposes for licensing in the pharmaceutical area, of course, is because it costs so much money to get a drug to market. It actually takes a village to get a drug approved and get it to all of us and to get it to people in other countries. Tufts Center for the Study of Drug Development every few years comes up with a study in which it analyzes how much money it costs to get a drug to market. And of course, that's a subject of huge debate and op-eds, et cetera. But their numbers have just come out. They came out in March of 2016, and it's based on data, actual data that came from 10 pharmaceutical companies on 106 drugs. And it was based on drugs that had first time in man between 1995 and 2007. So the numbers that have come out are $2.5 billion per NCE going all the way from start to finish. Now, that's a pretty eye-popping number. So if we break that down...
NCE stand, by the way, new chemical entity, new drugs.
Yeah, new drug, not a new use of an old drug, but a brand new drug, start to finish, identify, get it to approval, get it to market. So 1.4 billion out-of-pocket expenses for the preclinical, the discovery, getting it through all the way, going through the clinical trials. 1.1 billion, which they included, which maybe some people might think should be there and some people not, is an opportunity cost. Like, what could you be doing with that money instead? And how much interest could you be making on that money that you use instead to go through? There's also some of that 1.5 is the cost of failures, because, as you know, you take a number of drugs through and not all of them will get through. In fact, from first molecule to approval, it's about 10,000 to 1, but starting from initial drug discovery. Post-approval R&D costs, they measured at $312 million. That comes up to $2.87 billion in 2013 in dollars. So what do you have? You've got a high failure rate. You have a high cost of clinical trials. And we're running a lot of these clinical trials in the United States where the cost is the most expensive. And so Tufts says that the cost of drug discovery has gone up 145% in 10 years. That's a really big jump. So what does that mean for companies in the industry? And I've been in this industry for about 25 years, so I have a credibility check on those numbers and say, is that really real or is that bio-bucks, and I think in large part it's pretty real. I think the 1.5 million, at least the actual out-of-pocket expenses, it's tremendously expensive to get all the way through phase 3 clinical trials because you have to do large studies. And those, you might have to take 10 to 20,000 patients, and then you've got to pay for all those dossiers and et cetera. So it does meet the credibility test for the out-of-pocket expenses. So what does that mean for small to mid-cap pharmas? It means you can't develop a drug. There's no way. You don't have enough capital to get a drug to market. There are very few small to mid-cap pharmas or biotech companies that can also access enough money in the public market to do that. So they will have to partner with a large pharma or a partner that can come up with that kind of money. Large pharmas probably do have that kind of money on hand to take it from start to finish, but their issue is they're not very good innovators. And so they're very good at developing drugs. They're good at having sales markets, selling it all over, penetrating markets, getting global markets. They're great at that. Their track record on actually discovering drugs is pretty dismal. And so a lot of the large pharmas are going to the perhaps even 50% of licensing in drugs, and then they save the money on the upfront. They get a drug that's already hopefully in phase 1 or has a pretty complete clinical package, and then takes it on for there. So that looks like a marriage made in heaven: small or medium, good at innovating, not enough cash; large, great at taking it through. But they're not really coming up with the drugs. So that's why you're seeing so many license agreements. When I was at GSK, we were going through them on a monthly basis. It's just a churn. We're looking at compounds deals every single month and deciding on them. In terms of out licensing for pharma, large pharma generally does not do a lot of out licensing. There are a few large pharmas that will do it. I think AstraZeneca may have a program in out licensing. What they've pretty much found that it's almost not worth the time and internal time and going out to shop it. So you don't see a lot of out licensing. I think small companies would love to see that. because large pharmas have a lot of assets on their shelves that they just can't, they just don't have the bandwidth to develop, and those might be developed at a smaller cost with a company, but they don't really have the time to do it. So with that backdrop, let's look at 2015 in review. What did the licensing market look like last year for pharmaceuticals and biotech? Well, there were the 32 largest licensing deals of 2015. Of those, 15 of those, by far, the biggest licensing area is oncology. Okay, you're getting immuno-oncology, CAR-T, CRISPR. Those are the three big hot areas. Okay, the biggest deal of 2015 was the license from Juno to Celgene. Upfront payment, I'm sure you would all like this, $1 billion upfront payment. And that was in the area of CAR-T. And they had, many of you don't know what CAR-T is, okay? What that means is it's a chimeric antigen receptor for T cells, CAR-T. It's a technology where you can take let's say you have cancer, you can take your blood out, you can train your T cells to go back in and attack the cancer. So it's a way to genetically engineer your own T cells, and it's extremely hot right now. Obviously, $1 billion upfront payment, and that was a license agreement. That was not a corporate acquisition. That was a upfront license agreement, and they don't even say what the total amount is due. Regeneron did a license agreement with Sanofi on cancer antibodies, upfront payment $640 million for an antibody. AstraZeneca licensed something to Celgene, another cancer antibody, $450. Hamney licensed to Sanofi on a diabetes drug, $434,000. In terms of, in general, what the categories are, 15 were in oncology, 4 in central CNS, nervous system, 3 endocrine, 3 autoimmune, 2 infectious diseases. There was a big deal that was done between Johnson & Johnson and Achillion Pharmaceuticals in hepatitis C. Hep C is very hot right now. In main part because of a backlash to the Gilead pricing on the hepatitis C drug Sovaldi, and they were pricing it at about between $80,000, $100,000 a year per patient, and therefore the FDA is really pushing in some alternatives to that to get the price down. So it's nice when the FDA is giving attention to something as a means to get competition in the area to get prices down, as opposed to price controls. So licensing is, I would say, it's alive, flourishing, huge bucks involved. There are probably not as many people here in biotech as you would think today, because the huge biotech conference is going on as we speak out in San Francisco. There are probably 15,000 people at Bio from all over the world talking about these conferences and talking about these things and try to peddle or to find new assets to license. It's absolutely huge market right now. So it's hot, and it's basically feeding the next drugs. So let's talk about, we're talking about typically U.S. licensing. But what about international tech transfer for pharmaceuticals? Licensing out U.S. pharmaceuticals to other countries, you're not seeing a whole lot of that. We just had a panel about what's going on in China. WIPO had a conference last year which was on international technology transfer, and there were a number of representatives from developing countries there. And of course, they were saying, we want more technology transfer into our developing countries, because if you have assets you don't want, it's low-hanging fruit. License it to us, because it makes a difference in our market than your market. And how do we get that done? There were a lot of discussions about how do you get experience in developing countries in negotiating licenses. Some of them are starting to negotiate pharmaceutical licenses. Those are very complex licenses, because you have to understand both the technology, the science. You have to understand the regulatory environment in the U.S., the regulatory environment in Europe, in the developing country, and then how do you put it all together? That's a pretty sophisticated deal. and a lot of them feel like they're not particularly equipped or experienced to be able to negotiate that, so they feel like that they may not be getting the best deal. There are, and as speakers we were describing, we heard from LES, the head of LES today. That's a wonderful organization that helps with that, as does Autumn. But there is a discrepancy between the developed countries and the developing countries in terms of how do you negotiate a deal in the pharmaceutical and biotech area. And I explained to them, you're in good company. There are some of the biggest universities in the United States that still struggle with what are the right terms for a good pharma deal. But they want to see more deals. We think there's space for more deals. There's a lot of technology here that could be going to developing countries, and it would be good for us to be reaching out and either volunteering time, mentoring, helping those folks in developing countries and technology transfer offices to help them do deals. There's humanitarian licensing going on in the biotech and pharma area. Many of you have heard of WIPO research. That's being run right now by WIPO. It started out at GSK. In fact, I helped create the structure for the first patent pool for neglected tropical diseases. That came out of an initiative of Andrew Whitty at GSK, and he basically announced this at a press conference at Harvard. We hadn't even heard it first. He announced it and then called back and said, okay, I want you to make a patent pool. I've just announced it today. And we've got the press release, and so we had to figure out how to do what he's just announced we're about to do. So so basically, we went into our list of patents that we had, and we found 800 patents that touched on neglected tropical diseases. And we said, you sure you want to give these away? And said, yeah. So we posted them all on a website for GSK, and we invited everybody to come in and take a license to these at very low cost. And so guess what happened? Nothing. We got no calls. So we got all dressed up and nobody called. And the reason why is because it's very hard to just read a patent and access the technology. What they really want is know-how. If you want to teach somebody how to do something, you have to sit down and teach them. You can't hand them a patent and say, we're going to give you a low-cost license. It's just not enough for technology transfer. And we finally figured that out. When we added know-how to the deal, all of a sudden our phone started ringing. We got a lot of calls. So never underestimate know-how. There was a discussion this morning about know-how and patent licensing. Remember that if you do both, the royalty has to jump down after the patents expire. Recent case, Kimmel, which is affirming a prior Supreme Court case of Brulati. So you can't just have a patent and know-how license that goes on indefinitely. You have to have step downs. Really quickly, we'll just do one more thing, compulsory licensing. So compulsory licensing, very hot topic, sensitive topic in biotech and pharma. What we're seeing, of course, India is the hotbed of that. It comes out of TRIPS and Doha, the Doha Declaration. And it's the only technology in TRIPS for these compulsory licenses. And some of the countries use that as a negotiating aspect, because we have single payor systems in countries like Brazil and others. If they're going to negotiate, it's really nice to just say, give us the price you want, or else we'll have a compulsory license and we'll just give it to somebody else to sell. Really good negotiating tool. India gave its first compulsory license in 2012. That was Natco versus Bayer, anti-cancer drug. Brazil has given some in anti-AIDS drugs. Thailand has issued some in anti-AIDS drugs. I think that those compulsory license trends are going down because pharmaceutical companies are doing more deals with generic companies. And you'll know that in least developed countries, there's an exemption to patent infringement for pharmaceutical patents right now. A lot of people don't talk about that, but under TRIPS, up until 2033, there's an exemption to patent infringement to 91 least developed countries. So you don't need compulsory licenses in any of those countries because the patents are not enforceable. And then when you get to developing countries, what you're seeing is large pharmaceutical companies doing tiered pricing. And the most recent drama occurred in India with Sovaldi, the HCV drug. I was going through the patent office. There were a lot of oppositions filed, threatened compulsory licenses. What Gilead did was went out and granted something like 7 license agreements to generic companies in India to make it and sell it in all of the least developed countries. All of a sudden, the oppositions fell away and the compulsory licenses kind of fell away and the drama's down now. But you've got 7 generic companies in India making Sovaldi. So with that, I'll now turn it over to Issi.
So my organization, the Broad Institute, which is based on the collaborations between MIT, Harvard, and the Harvard teaching hospitals, works in the very, very beginning of that drug discovery process. But Sherry explained very well the reason why we absolutely need the patent protections and we need to do licenses, because we work on basic discovery. We do some early stage drug discovery as well. If we don't protect our assets, there is absolutely no way that anyone like Sherry's former company, GSK, will develop it and bring it to market, because nobody in their right mind will invest $2.5 billion without patent protections and ability to block others from selling the same drug. So I will focus on licensing strategy of a technology that Sherry mentions, the CRISPR technology. The CRISPR technology is a new gene editing technology. It allows you to very simply, fast, efficiently, and precisely edit genes. Why is that important? It's important. It has multiple implications. One, in the easiest one, the fastest one, and the one that's been now used in almost every biology lab in the world is for research. You can go and edit genes and see what happens. Try to investigate biologies just to understand the functions of genes, try to understand which genes are implicated in diseases, and that enables all that research. Another use of it, of course, if you think many diseases are genetic-based, so there's the genetic component to disease. So if you can go and fix the genetic mutations that maybe causes the disease, it's actually a cure. It's a cure for genetic diseases, so monogenic genetic diseases. So I have this discovery, I have those patents covering CRISPR, and I'm supposed to figure out what's the right licensing strategy of this technology. It's not a simple matter. It's not a simple matter because we want to ensure that this technology gets utilized the best way it can, that it reaches the most hands it can, and it actually also get developed as a therapeutic, which we just learned you need exclusivity for. So how do I balance all those aspects of making some important discovery available? Now, luckily, we're not for profit. So the number one most important thing for us is public benefit. So my first criteria of how to license technology is to ensure public benefit. So we came up with a strategy that has a number of components. So for the first application as a therapy, actually, let's start with maybe more basic applications. We make all our technology available for all academic research, not-for-profit research, free of charge. Everybody can use our technologies in any academic lab in the world. Beyond that, we actually share reagents with them. So I think up to date, this is a new technology. It's only been discovered the last few years. We shared over 30,000 reagents from the Broad with academic institutions. And we just do it, no licenses required, we just share those. The second application is a research tool. As I said, it's a very important tool to investigate biology. So it's clear to us that the application in research has to be non-exclusive. We already gave it to all the academic labs. Now, what happens to all the companies who want to use it internally for research? What happens to the companies who want to create research reagents and share them with the world or sell them to other companies? So this was clear to us has to be non-exclusive. So we've carved this out as a non-exclusive license, and we've done multiple of those. Another applications, of course, is non-exclusive is in the ag field. This is a technology that's very useful for ag to create better yields, crops are protected from pests, and so forth, to really increase the ability of the availability of food supply. We made it also available exclusively. And now we got this problem of how do you license it as a therapeutic to allow people to invest the billions of dollars needed to invest and make it as a therapeutic, but still ensuring it gets broadly developed, because no single company can develop that many therapeutics. See, there are thousands of genetic diseases. No single company can develop it. However, no investor will invest in a company without the promise of exclusivity. So this is where we struggled a little bit for a while to figure out what the right model is, and we came with a model we now call it inclusive innovation model. So we license it into a company funded by the top 3 venture investments in biotech. We gave them the exclusivity for the therapeutic applications of the technology, but we limited it. We first limited by certain time horizon that we let the company figure out what diseases it goes after. And after this initial period, what we've done is we opened it up for any other company to claim on a gene-by-gene basis other targets that the technology can be applied to. So, for example, if there is a disease that gene X is implicated in the disease, the startup company to which we license the technology is not developing a therapeutic against that gene. They have to release the exclusivity of the technology around that target. So with this mechanism, we believe, one, we enable the funding needed to the biotech company, which, by the way, went public in early February, and it's the most successful IPO to date this year. So the market accepted this type of licensing strategy with the success of the IPO. We also enabled the release of all the targets, all the diseases this company will not be applying the technology to be addressed by other companies. They can come, make a proposal, says, I have a proposal, this is my development for these targets, and there is a mechanism by which they can get the access to technology for those specific targets. And for all the research applications, we just do it on a non-exclusive basis. You can imagine that licensing strategy was unusual, so the set of investors we worked with to enable this were not that happy in the beginning. They says, well, this makes it very difficult to create value, but as I said, with the success of the IPO, we've proven that no, you can create value and be very thoughtful and put public interest ahead of financial interest of the investors, and still be able to create structures that allows you to develop the technology very broadly and for specific disease areas, and make it available as a drug, hopefully one day.
Thank you, Issi. I forgot what I mentioned. Lian, former you were with Biotechnology Industry Organization, the Chief Asia Advisor, but her current affiliation with your law firm, one of the main partners. One of the main things that Lian does right now is to license, help U.S. universities and startup companies license their technologies into China, and also inventions in China coming here. But for our audience today, perhaps focus on the first aspect, U.S. universities and startups, their inventions, how do you help them licensing their technologies into China? Is it the challenges, the opportunities in that regard? Thank you.
Thank you. Thank you for inviting me here. Also, I was a former examiner, so it's always good to come to my, the same group of people I know so well. So I've been working in the biotech patent field in the company setting for more than 10 years. Then I started to work on the business side. And during the business, I helped bio, and then later on the Chinese companies, and they asked me to identify the U.S. technologies, and so they can license. But that was early stage. They were just looking, but no action. Just recently, we found really good opportunities now, but all of a sudden we realized, there's a lot of money there in China, and so we have a law firm helping just a special, this is probably the biggest group of just Chinese lawyers educated in U.S. from this firm, helping the Chinese companies and the clients, they do business in U.S. The reason what happened, as you know, the new 13th five-year plan, biotech is also a big pillar. And the Chinese, again, the government, because so far the problem in China is all the Chinese pharmaceutical companies are generic majority, hardly any new drugs right now. So the government's in a hurry to look for the new drugs, encourage for the invention. They just they have a goal. It's not like market oriented as Mark mentioned. It's everything government set a policy. We need to have how many new drugs in this, in this 5 years. So they have a goal. So everyone now, companies rush to U.S. is the biggest market. They come to U.S., look for the technology.
I believe there's a specific number, 30 NCE, 30 new chemical entity or something.
Yeah. I mean, this is something we try to tell them. It's an invention. How can you set a number, But there's a number there you have to look for, so everyone's coming. So used to be all the pharmaceutical companies, generic companies coming to here. But now, a lot of fund, they call fund, PE fund, whatever fund coming here. So the fund is also, the fund interesting because a lot of people, they make those money not from biotech. It's from real estate. And I have another client, their fund is from selling the high-speed train. So they made a lot of money. So the next goal is they want to do something like a God type of thing. So they want to save their life. They come to the life science. That's interesting. I feel like all these people, at the end, they all want to feel good, and they invest in the life technology. So life science. So they come to U.S. A lot of fund coming to U.S., a lot of company coming to U.S. to look for technologies. And so I was in Women in Licensing group in New York and in D.C. I know a lot of tech transfer people. So they've been approached by the Stanford was approached, Rockefeller University was approached, Columbia and New York University. They said, we're being approached by a lot of Chinese group asking for the technologies, but we don't know who to trust. Because they ask, we don't know what to do. Because, again, the U.S. side is worried about the IP, how to protect the IP. Then, meanwhile, I asked the Chinese side, I said, what's your concern? So their concern is the technology is too early stage in the U.S. Second, they say, well, they only give me a piece of IP, and most university wouldn't guarantee a know-how. What if I pay the money, the technology doesn't work? What do I do? So I've been encountering these two sides of argument, and then try to facilitate the communication. That's there's a communication breakdown on also the trust break, because university, they wouldn't put in the license saying we guarantee the technologies are going to be enabled in the, we only give the license a patent. We wouldn't guarantee the technology is enabled. But Chinese side, why do I need a piece of paper if the technology is not enabled? And what if I couldn't do it? But the life science has a lot of tricky. You need a lot of know-how to help to make sure that it works. So this is the problem. So another thing is nowadays, instead of they license the technology all to China, they have another thing. They set up incubator. I live in Palo Alto. We see a lot. We see the Chinese delegation. I belong to a lot of associations, so I help them. They come almost every month. There's different province, a Chinese delegation coming over, looking for space. The lab space is really hard to get now. So they set incubator in different area in the Bay Area. One area is in East Bay called the Joint. There's a park. They bought a really nice site. You can oversee the water. In Richmond used to be Burlex. Now and then Bayer bought it, and then the Chinese company bought it. So they have an incubator there. And even recently, the former Minister of Health visited there, Chen. They had a big conference, showcase the technology. Actually, the Chinese scientist technology made in Bay Area. So they have showcase on these events. So that this way they feel comfortable that they have good way of developing early stage technology, and then they can transfer, once it's mature, they can transfer back to China to make sure, license to the Chinese company. This is the other thing is the big pharmaceutical company, they also set up their own R&D facility in New Jersey. There's one of the big one called Huahai. They bought a manufacturer site just in New Jersey. And there's another company, Cluas, also have they have a manufacturer site in New Jersey too. So they want to copy how U.S. developed this this kind of drug, and then they have the BD people just go to everywhere. Like in this time in bio, I have several friends. They are used to work for the GSK, all these companies. Now they work for the Chinese companies. Go to all these partnership meetings, and especially looking for the early stage university technology. And these are U.S. educated, trained scientists who had MBA and working for them. So I see a lot of trend. But the other thing is why there are a lot of money. I just recently, there's an article about China. I mean, there's a lot of things about China. The political system is not as stable as it used to be. There's a lot of crackdown on the corruptions, but it's overreaching to a lot of people. So when I go back to China very often. And then when I talk to those government officials, they say we're afraid to do anything because if we do something more, I might be the next target. So it's slowed down. So that slowdown actually caused a lot of instability around the people, rich people. So they're moving money out. So last year, the whole year, 2015, there are about $675 billion coming out of China to all over the world. I guess majority money coming to United States.
Looking for opportunities to license U.S. technology. That's one of the goals, I guess.
Yeah. I mean, they think that the technologies, and that's, again, the one I met recently in New York is he made, from real estate, he made $6 billion. He's doing all the life science investment, partially here, partially in China. When I have a technology myself, I'm interested in licensing from Stanford University. He reviewed it. He saw that's interesting, but he doesn't understand it. He only look at who are you bring with. So they want you to, the thing is, they still don't understand early, it's not as sophisticated as American, they recognize early stage, you need some time to do it. So they say, well, instead of that, I look at the team. Who would bring the best team? If you have Nobel laureate, if you have someone who has done several companies, well, I trust you, then I'll put the money in. So that's, again, that's something, needs some time to mature, but still, it's getting more and more big. So in a way we're talking about, there are a lot of, so what they're working on is they're looking at for the Chinese educated in U.S. and then bring the technology to China. So this is the kind of bridge the Chinese side is using. But then there's another issue of espionage, causing a lot of espionage issue in the U.S. The Chinese scientists bring the microorganism, and they got prosecuted some. So there's a balancing issue here. So that's why I think a lot of companies here, they just set up this facility in the U.S. now to work on. So given that, I think it's still in the mature Chinese, this tech transfer thing is still in the very early stage. Universities they have tech transfer office, but they're not very active. So it's in the developing stage, but it will be getting bigger and bigger. So there will be more and more the China. By the way, they're looking for more like China rights. They're not looking for global rights that much. So that more and more the Chinese company will come to U.S. looking for the opportunities, licensing opportunities.
Thank you, Lian. So with that, I want to kind of tie in, thank you all three of you, with the theme that I mentioned, the extreme high risk of the life science investment, life science invention, commercialization. And I think licensing is sort of as a way of spreading, as Sherry already mentioned, spreading risks among players. Because if you don't have some sort of a reasonable expectation at the end of the tunnel, nobody in your right mind will carry the risk through from the beginning to the very end. And so the extreme high risk, how do you handle that risk? How do you spread that risk? And the second theme is how do you balance the human needs versus the revenue generation, easy tied in broad approach to this. How do you come up with a sort of innovative, inclusive licensing model? It took a lot of effort to negotiate. It's not easy, as Issi mentioned, to kind of balance public benefit versus the necessity of having some exclusive rights, so that for investors with billions of dollars invested, there has to be some return. So how do you balance kind of optimal allocation or balance public interest versus the necessity of return on the investment on this high-risk area? And with that, perhaps I can continue a little bit with what Lin said on the cross-border challenges, particularly when you license technologies into China. Mark actually and some other people already provided good segue into this, and that is, again, risk allocation. Let me perhaps ask the panelists, I want to open to the audience as well. The first time I'm doing this, but when you do licensing deals, do you want to allocate the risks among yourselves between licensor and licensee, whatever way you want, or do you want some regulation to tell you how to allocate that risk? To the extent that your answer is yes, I very much would like to hear why. And we may not have time to actually. Let me just share a little bit. Let me give audience and you three some time as well. Do you like to allocate your risk as you see fit, whatever way you want, or do you want some regulation to tell you how to allocate improvements, how to allocate, as Mark mentioned, risk of third-party lawsuit? I think I heard Lian. I think I may have misheard you. I think one of the concerns that Lian mentioned is the licensing technology. The licensee said, "Oh, you cannot guarantee." There's like no third-party infringement. You cannot guarantee absolute freedom of operation. No, I'm not going to license. That's similar. That's tie into this risk allocation that I'm talking about, and that is one of the main engagement that the U.S. government is dealing with China. Is to very simple question, very basic. When licensors and licensee get together, they do a licensing deal. What is better? A, allocate risk as you see fit, whatever way. Number two, no, you have to allocate this way. There's a regulation.
At the risk of asking Mark to answer that question, I think he's already given us the answer to that question, and obviously the practice in China of requiring certain terms in a license agreement is anathema to anyone in the United States or in the developed world in negotiating license agreements. It's And Mark raised some of the issues in terms of the fact that it's actually an insurance policy, and most U.S. companies are not going to voluntarily give an insurance policy, especially when you're talking about developing drugs. And there's there's another overlay of that when you're developing drugs in China, because you've also got the data exclusivity issue. And, in the United States, you'll get 5 years of data exclusivity through the FDA if you get approval of a new drug, and then you can go into Hatch-Waxman litigation and kind of keep going from there. And so you can have a de facto form of exclusivity, which is a form of regulatory exclusivity for a certain number of years. The law is not that strong in China, we had a couple of situations in China, one in particular where we had an HPV agent that was going through regulatory review in China. The generic actually got theirs approved before we did, and so they were the first ones on the market. And that was because, and of course they used our data, because you can use publicly available data in China. You don't have to actually, use the dossier that the company has presented. They can use scientific papers. I think this was before clinicaltrials.gov, so there wasn't a required website with clinical trial data. But they could go to, peer-reviewed journals, and they would give that to the SFDA, and the SFDA, of course, for all the reasons we've talked about today, had an interest in having the Chinese company be the first on the market with this HPV agent, and they beat us. And we're saying, what? So they're actually infringing our patent, and they're the generic, and they were the first on the market. Now, put all that in your head and figure out how that gets sorted out. And then you have to take them to court. Well, they're the government's the first one to approve that drug, and now you're going to sue them for patent infringement in their court. So it gets kind of sticky. It gets a little bit sticky there. We had a situation, a really interesting situation, where in China, I don't know how many of you understand, FDA approval or the Orange Book stuff, but what happens in the U.S. is when you're getting a drug approved, you submit a list of the patents that you have, which cover the compound or the method of use of the compound that fall under the label that you get approved, and that's what's called the Orange Book. And if the generic company has to certify, and those are the patents that you sue on in Hatch-Waxman litigation. Well, in China, they have the opposite. What they have, the innovator does not give the list of patents. What happens is the generic company, when it asks for approval to sell a drug, it has to put the list of all the patents that it's aware of that it might be infringing if it goes on the market. Well, surprise, sometimes they don't have the most relevant patents on that list. And we ran into a situation in China where we got wind of the fact that one of the generics was developing one of our drugs. We actually sent them the Chinese patent and said, if you go on the market, you're going to be infringing our patent, and we're going to sue you and, ask for a preliminary injunction. We had all of our letters, all of our ducks in a row, saying that we'd given them fair warning that we had a patent. Well, we couldn't figure out how they were still going through to get approval. And then we saw their application for approval, and they had not written on their request for approval at the SFDA the patents which we had given them notice of, as directly infringing. So that was a really interesting question, and it was a question that had never been, in my mind, to our research, ever addressed in China. So we went to a really very savvy litigator in Beijing, and we talked about strategy, and we said, okay, let's file a lawsuit. There's never been a lawsuit like this in China. Let's file a lawsuit that says you can't, basically we told the FDA they're infringing our patent, and this patent should have been on here, so you shouldn't approve it. And they said, well, we can't keep the drug off because it was not listed on theirs. And we said, well, it should have been. They said, well, it was not. We said, here's the letter. It doesn't matter. It's not there. So they couldn't keep the drug off. So we filed a complaint in China that said that the generic company had the obligation to tell the truth to the SFDA, and when they signed this document and submission for that they, and in fact, one of the regulations is that the form will be filled out to the best of your knowledge and to your truth. Okay, so we said that they insulted the Chinese government by telling them something that was false on the record, that they lied to the Chinese government, that they knew that. We attached the letters, and we said that it insulted the dignity of the SFDA, and that they should stop. They should stop them from, from selling this drug. Well, they had never seen a complaint like that before, and of course, why not? Because we just made it up, and so they'd never seen one like that before. So it got filed in Beijing People's Court number 2, and I don't know if you know this, but in China, no complaints are as of right. The court takes the complaint and decides whether it wants to hear it or not. And so there's no absolute right to file a complaint in China. So you file this complaint, and then if it looks a little odd, it will go to a group of judges that decide whether the court wants to hear this complaint. And if not, they'll just hand it right back to you. We don't want to hear this one. So we didn't know if they would take it. So that's why we put in as many statements as we could in the complaint about how this company was insulting the Chinese government. And so they got this, and it was like, well, wait a minute. Here's a generic. We want to protect the generic. This is how we've got this set up to get them on the market. But they're saying that they're insulting the Chinese government. We can't really let them do that. And so the judges got together and said, okay, we're going to take this complaint. And then the SFDA said, wait a minute, you can't take that complaint because we've just talked to them and we said it's not on there. And the judges said, well, we have to. They're insulting the government. And it was very funny, actually. So we got into court with that. But then what happened was the generic company then challenged the patent, and they quickly upheld the fact that the patent was invalid. And then all done. And then the lawsuit had to be dropped. So they got it through the patent, not through the litigation. But the interesting thing was we actually got into court with that complaint. And it's a very interesting dynamic about, Chinese politics. And, I wish we could say we kept them off, but we actually got them to hear it.
Thank you, Sherry. It's actually a couple issues Sherry mentioned. We don't have time to get into the detail, but let me just quickly summarize. The data exclusivity issue with the generic company for limited time and not supposed to be able to piggy ride on the brand name innovator's data. You can feel free to reach out to me, reach out to Sherry, to my colleague Mark and Elaine. That's one of the big issues they're working on. Also, the case registration system. There are some limited improvement by case registration system. I mean, U.S., you file the case, the court has to take it. If you don't take it, you got to write down, I don't take this case because X. And the Chinese system is a little black box. You don't know where the case went. To the question whether the court takes the case or not. Let me spend 2 minutes, if I can, to tie in another issue that Sherry already alluded to, the data supplementation issue. And that relates to the ability for the innovators in the life science industry to get a patent. And the unique aspect of that, of course, value per patent in the life science industry. I don't have the number, but how many times of patent, let's say, in cell phone or IT industry. Again, those are all wonderful industries, all important, but the value per patent is probably easily 3, 4, 5 magnitude. So the ability for the innovators to get a patent and the data supplementation issue ties into that is, Sherry mentioned a little bit already, after you file a patent application, normally you're not supposed to submit additional material. Oh, sorry, I forgot this. Oh, sorry, I forgot that. Just take it. You file application, done. That's your application. However, there are important exceptions that you can submit your supplemental data, for example, to show my invention is non-obvious because it's surprising. I've got this surprising result. The data is supplemental. It's not in the application. In US, Europe, Korea, Japan, it's pretty consensus rule under what circumstances. It's pretty flexible rule, pretty flexible standard that you can submit your supplemental data to show that, and for some other purposes as well. In China, however, we've pushed, and I think we can summarize this: it's not zero anymore. It used to be absolutely zero. Right now, it may be 10. So we're still fighting, and in fact, the last November 2015 delegation headed by former Judge Rader from the U.S. We went to SIPO and China's IP court with the PowerPoint slides with translated cases from U.S., Europe, Korea, and Japan to show them the practice of other, we call it the other IP5s, other means other than China, and in particular, how this policy going to hurt Chinese innovators, because as a Chinese innovator, because this rule, I gotta get all my data ready. I need 5 data points, let's say in the U.S., Europe, Korea, Japan, to file my patent application. But in the Chinese system, no, I need 20. I need 50 data points. Okay, let me wait. Let me get all these data points ready. Then I file in China, of course. Then I go to U.S. Oops, someone already filed U.S. Oops, I go to Europe. Someone already filed, because in that 1 year or 2 year, I was putting together the 45 additional data points. That hurts the Chinese innovators much worse than the foreign innovators. So that's an additional layer to hurting innovator and hurting Chinese innovators in the life science industry in particular. Because of limited time, let's wrap up, and you've got an exciting panel coming up, summarize perhaps the most important theme of today's program, and what the government can do to promote, to encourage licensing. The roundtable after this, the government's role with a list of distinguished speakers from key agencies. Before we can let Lian.
Oh, I just want to add, when you're talking about this data, post-filing data, actually Chinese company, like a pharmaceutical, they're fighting that too. They told me they are very frustrated with the government of this policy, like Fosun Pharmaceutical, and that's one party, if you guys want to reach out to them, they are frustrated. So right now the strategy is, I told them, whatever you have, just file, and not to wait till you have complete data. Just file as much as you can. Just keep as it. So nowadays, the Chinese actually side, they understand. They're going to use. They usually told us, they say, well, why don't you draft the application for us? We translate it into Chinese, then we file in China. And then in one way, it's standard. And the second, also, they get Chinese government to support the payment, some of the subsidies on the payment.
I wonder if this rule against retroactivity would hurt. If they change the rule and say going forward you don't have data, would that mean as of that filing date, or would that correct the problem for everything that's pending right now?
That's an interesting point, but let's go offline to go into more detail on that. Let's perhaps take a 5 minutes short break before coming back for the government for the roundtable on the government's role in promoting encouraged licensing and. Sorry, a round of applause for Issi, for